please be seated. To give her opening remarks, please welcome Dean Darlene Marie B. Berberabe, Dean of the UP College of Law and ex-official trustee of the Malcolm Foundation. Dean Berberabe.
Maraming salamat, Prof. Paulo Tamase. Good afternoon to everyone and welcome to the UP College of Law, BGC campus. I'd like to greet PALS President, Filipino Association of Law Schools President Teddy Pastrana, SEC Commissioner Roger Quevedo, also a member of our faculty, LEB Commissioner Lorenzo Reyes, esteemed members of the faculty of UP Law, our Honorable Senator Robin Padilla, our esteemed panelists will be introduced later. Ladies and gentlemen, good afternoon. In the last 25 years, the Philippines has witnessed impeachment proceedings against 5 high-ranking officials. President Joseph Estrada in 2000, impeached by the House of Representatives on charges including bribery, graft, and corruption. Ombudsman Merceditas Gutierrez in 2011 for alleged inaction on high-profile cases. She resigned before the Senate trial commenced. Chief Justice Renato Corona in 2011, impeached for betrayal of public trust and culpable violation of the Constitution. The Senate convicted and removed him from office in 2012. Commission on Elections Chairman Andres Bautista, 2017, impeached over allegations of unexplained wealth. He resigned before the Senate could conduct a trial. And Vice President Sara Duterte in 2025, impeached by the House on February 5, 2025 on charges including misuse of public funds and threats against the President. Her Senate trial is pending. While impeachment serves as a crucial check on power, excessive impeachment proceedings may indicate deeper issues such as political instability and institutional dysfunction. Impeachment ensures that high-ranking officials remain accountable for corruption, abuse of power, and violations of the Constitution. A high number of impeachment cases may reflect robust democratic framework where misconduct is actively challenged. However, they may also destabilize the government, making it difficult for leaders to implement policies and maintain political continuity. It can result in a cycle of political revenge where impeachments are used as a tool to remove opponents rather than address legitimate abuses. If impeachments are fair, transparent, and based on evidence, they boost public confidence in democratic institutions. However, if impeachment is used as a political weapon, it can lead to distrust in government and create divisions among citizens. In healthy democracies, impeachment upholds the rule of law by holding officials accountable. In weaker systems, frequent impeachment attempts may indicate political weaponization. The significance of having many impeachment cases depends on how they are used. If impeachment is legitimately used, it strengthens democracy, accountability, and governance. The academic community plays a critical role in ensuring an informed, objective, and evidence-based impeachment process. Scholars, universities, and research institutions contribute to legal analysis, public discourse, and historical documentation. Their role is crucial in promoting fairness, democratic stability, and public trust. During impeachment proceedings, we act as neutral bodies that assess whether impeachment proceedings are legally and ethically justified. Thank you everyone for your time in this important forum to listen, understand, or participate.
Thank you, Dean Berberabe. This forum features two panels. The first on emerging issues in impeachment, and the second on the Duterte impeachment in particular and lessons from the past. To introduce our panelists for the first, please welcome Professor Fina Bernadette A. de la Cuesta Tantuico, Secretary of the Malcolm Foundation and member of the UP Law Faculty. Professor Tantuico.
Good afternoon. It is our privilege to be joined by a diverse panel of experts who can speak from an academic and practical level about emerging issues in impeachment. So my task this afternoon is to give you a brief profile of each of our speakers. First off, we have none other than the Honorable Franklin M. Drilon, former Senate President and member of the Estrada and Corona impeachment courts. He was a former member of the Senate of the Philippines with the distinction as its longest-serving member. He also served as Senate President for the 10th, 11th, 12th, and 13th Congress. Senator Drilon participated in the impeachment trials of former President Joseph Estrada in 2000 and former Chief Justice Renato Corona in 2011 as a member of both impeachment courts. Prior to his service in the Senate, Senator Drilon served as Secretary of Labor and Employment, Secretary of Justice, and Executive Secretary of Presidents Corazon Aquino and Fidel V. Ramos. He was also formerly the managing partner of Accra Law. He graduated from the UP College of Law in 1969 and placed third in the bar exams held in the same year. In 2014, he was conferred the degree of Doctor of Laws honoris causa by the university. Our second speaker is none other than the Honorable Conchita Carpio Morales, former Associate Justice of the Supreme Court and former Ombudsman. She served as an Associate Justice of the Supreme Court from 2002 until 2011. She is the ponente of the Francisco versus House of Representatives case, the 2004 Supreme Court decision that barred the impeachment complaints against then Chief Justice Davide. Soon after her retirement, she was appointed by former President Aquino to be the 5th Ombudsman. She obtained her Bachelor of Laws in 1968 from the UP College of Law. In 2016, she was conferred the Doctor of Laws honoris causa, recognizing her 28 years service to the judiciary unmarked by any accusation of impropriety, and for being herself the measure of integrity in government service and the face of courage and daring determination, of competence and independence, and one of resolutely intolerant of corruption. In 2016, Ombudsman Carpio Morales was one of the 6 recipients of the prestigious Ramon Magsaysay Award. Our third speaker was a member of the 1986 Constitutional Commission, the Honorable Rene V. Sarmiento. From the 1986 Constitutional Commission, which drafted the 1987 Constitution. He served as member and later vice chairman of the Philippine panel negotiating with the Communist Party of the Philippines New People's Army National Democratic Front movement. He was appointed as Deputy Presidential Advisor on the peace process in 2005 and became Officer in Charge, Presidential Advisor on the peace process from 2005 to 2006. Honorable Sarmiento later served as Commissioner of the Commission on Elections from 2006 to 2013. He obtained his law degree in 1978 from the UP College of Law, where he was the president of the UP Law Student Government. He was a professor at the Polytechnic University of the Philippines College of Law and the San Beda College of Law, teaching constitutional law, human rights law, and election law. Our next speaker will be Associate Professor Gwen Grecia de Vera from the UP College of Law. She is the current Program Director of the UP Law Center's Competition Law and Policy Program. She previously served as Dean of the Manuel L. Quezon University School of Law and the first Executive Director of the Philippine Competition Commission. She previously served as a bar examiner in political law and public international law for the combined 2020 to 2021 bar exams. She currently teaches constitutional law in the UP College of Law and has lectured at the Angeles University Foundation and the Ateneo de Manila University School of Law. She obtained her Bachelor of Laws degree from the UP College of Law in 1995. She placed 7th in the 1996 bar examinations. She obtained her Master of Laws degree from Northwestern University School of Law in 2010. The last speaker in our panel, in this first panel, is Professor Theodore Te, also from the UP College of Law, the former spokesperson of the Supreme Court. As a lawyer from the Free Legal Assistance Group, Professor Te notably served as counsel for Leo Echegaray, as well as Rappler founder and Nobel Peace Prize recipient Maria Ressa. He graduated from the UP College of Law in 1990 and obtained his Master of Laws degree from Columbia Law School in 2012. He currently teaches evidence and heads the college's Clinical Legal Education program as Director of the UP Office of Legal Aid and the clinical head of the Civil and Political Rights Clinic. Both panel discussions today will be moderated by no other than Assistant Professor Paulo Tamase, the Assistant Secretary of the Malcolm Foundation. He is an assistant professor of the UP College of Law who teaches constitutional law, administrative law, public officers, legal history, and comparative law in the UP College of Law, where he also serves as assistant to the Dean for Academic Affairs. He obtained his Bachelor of Science in Business Economics magna cum laude from the UP in 2012 and his Juris Doctor from the college in 2016, graduating as valedictorian and serving as chair of the Philippine Law Journal. He obtained his Master of Laws in 2022 from Yale Law School, researching on comparative administrative law and comparative and constitutional law and economics. Ladies and gentlemen, with that formidable roster of panelists, I am confident that we will all benefit from a productive and enlightening afternoon. Thank you very much.
Thank you, Prof. Fina. May I invite our 5 panelists for the first panel on emerging issues and impeachment to please come up the stage and join us here. To give our audience an idea of how we'll do the panel, so we, over the weekend, thank you to our speakers and panelists for agreeing to join us on a very short notice. we transmitted to them a list of questions on emerging issues that we would like to discuss for today. But before we get to those 5 questions, we had invited them to provide first opening remarks if they wish to. We understand that most of them do not want to give initial remarks, but that Commissioner Sarmiento did prepare a short presentation for all of us today. So unless anyone else would like to begin, then may I call on Commissioner Sarmiento to present.
Senator Frank Drilon, my colleague in the Government Peace Panel, negotiating with the CPP, NPA, and DF for many years. Our Justice Carpio Morales, our 2 professors from the UP College of Law, Professor Gwen, Professor Ted, my colleague in the Free Legal Assistance Group, my co-panelist of the second panel, and of course our beloved Dean of the UP College of Law, Dean Darlene. She's the darling of the College of Law. To the students of law, to lawyers, representatives of the House and the Senate, Senator Robin Padilla, guests, ladies and gentlemen. May I go direct to the point? In the ongoing national conversation on impeachment, 3 issues emerge. And what are these? Number 1, can the Senate of the 20th Congress continue the impeachment trial that has started during the Senate of the 19th Congress? Number 2, can the Senate forthwith proceed with the impeachment trial even during recess? And number 3, can the President call a special session at any time? My answer to issue number 1 is yes. This has been addressed in the case of Pimentel Jr. versus Joint Congress Committee to canvass the votes for the President and Vice President, a 2004 decision, where our beloved Justice Carpio penned her separate concurring opinion. Petitioner Aquilino Pimentel Jr. asked the Supreme Court to annul the proceedings before the JCC because it has become functus officio because of the new Congress. But petition was denied by the Supreme Court in an en banc resolution. The Supreme Court making a distinction between legislative function and non-legislative function. The Supreme Court saying that it has not become a functus officio insofar as non-legislative function, meaning outside of legislation, it has a continuing function. It could be convening as a canvassing board. It could even be serving as an impeachment court. And a separate concurring opinion, our esteemed Justice Carpio Morales, citing the extensive deliberations in the 1986 Constitutional Commission, in the exchanges between Commissioner Maambong, a former lawmaker, and Commissioner Davide, a former lawmaker. She wrote that again, repeating the legislative and non-legislative function of Congress. So yes, it has been functus officio insofar as performing its legislative functions, but not its non-legislative function, which is continuing. My answer to issue number 2 is yes. Po ang mainit na pinag-uusapan po ngayon sa ating lipunan. Further proceed, or in the Tagalog version of the 87 Constitution, dapat agad isunod, is a novel addition in the 1987 Constitution on impeachment, not found in the 1935, not found in the 1973 Constitutions, not even in the US 1787 Constitution. In ordinary meaning, as constitutionally interpreted, it means right away. It means immediately. Walang patumpik-tumpik. Walang alinlangan. Gawin kaagad. The records of the 1986 Constitutional Commission are there. When forthwith proceed was introduced, it was part of the committee report number 17 on accountability of public officers and submitted for plenary discussion on July 26, 1986. Yours truly was the acting floor leader when this committee report, which includes forthwith proceed, was presented on the floor. Absent discussion on forthwith proceed, its immediacy and urgency can be drawn from the intent of the framers of the Constitution, from the exchanges of the members of that commission on the time-compelling significance of impeachment. Commissioner Regalado Maambong, citing, quote, power of impeachment guide to Congress, said that impeachment is not personal punishment or vendetta, but primarily to maintain constitutional government. The President is called to account for abusing powers which only he possesses that have a tendency to subvert constitutional government. And it will include other impeachable officers. Commissioner Blas Ople, in his poetic language, his usual poetic ornate language, stated that impeachment is a sword in the scabbard. It is as good as a sword drawn. It is not a constitutional decoration or a tinsel, but a powerful check on the presidency. The prospect of an impeachment trial, according to him, caused then U.S. President Richard Nixon to resign. Commissioner Felicitas Aquino inputted that impeachment is in the nature of an exemplary act by which the state infuses the highest sense of responsibility to public service. Finally, Christian Monson said that it is a deterrent and added that President Marcos Sr. exerted all efforts at that time to defeat the impeachment proceedings and the subsequent calling of a snap election at the time may have been influenced to some extent by an attempt at impeaching him. We go to question number 3. Question number 3 is, can the President at any time call a special session? My answer to issue number 3 is yes, is also yes. The President may at any time call a special session of Congress. The 1973 Constitution says the Prime Minister may call the National Assembly to session at any time, quote, to consider such subjects or legislation as he may designate. The 1987 Constitution provides that, quote, the President may call a special session at any time. The Philippine experience is that President Elpidio Quirino and President Gloria Macapagal Arroyo, in separate proclamations, called a special session of Congress. Quirino called for a special session to address insurance loss concerns in the Philippines. President GMA to address the VAT issue at the time. In the US, the President has called a special session of Congress to tackle issues related to war, economic crisis, ratification of treaties, and others. It's more broad in the US. And the President calls for a special session. May President BBM, our wish, call a special session of the Senate to start the impeachment trial. Of the three issues, the first best option to me, is forthwith proceed. Reasons were already given. The second best is a special session. And the third best is the new Congress continuing the impeachment trial if it is not done before Congress adjourns on June 13, 2025. In the light of these intractable emerging issues, I humbly suggest a National Day of Prayer to beseech God Almighty for guidance and wisdom. Benjamin Franklin introduced the idea of prayer in the sessions of the 1787 Constitutional Convention, realizing the importance of prayer, God's powerful role in the life of nations in shaping their destinies. The same reason why George Washington, in his oath-taking as the first president of the United States, added in the presidential oath, "So help me God." And thereafter, future presidents all over the world included "So help me God" and their swearing in ceremonies. Well, this may be difficult times in our country. The impasse on this issue of impeachment impacts our country politically and economically. The soonest this issue is put to rest by wise and bold choice of any of the options I have mentioned, the better for our country to become wiser, stronger, and God-praising. Yes, the worst of times can be the best of times. Maraming salamat po.